As we are here just asking a few questions regarding matters to do with succession, inheritance, and that kind of thing. I'm here accompanied by my colleagues who I'd asked that they introduce themselves. First of all, to the far left, I'd like to ask the lady to introduce herself.
My name is Cynthia Musembi. I am an associate advocate at the firm of Musembi and Company Advocates. I mostly deal with litigation matters, some commercial matters. Yes.
Okay, great. And the lady to my immediate left.
Yes, I'm Mbugua. I'm a partner at Musembi and Company. I've practiced law for 26 years in commercial division and also the family division.
Right, amazing. Thanks for that. I mean, one of the questions that arises when you're talking about wills, succession, and that kind of thing is defining these things. So, Cynthia, what is a will? And people talk about it as a big thing. Kiswahili, they say wasia. What is a will?
Well, a will is just simply a document that is prepared by an individual who desires to give instruction as to how his property should be distributed upon his or her demise.
Okay.
Yes.
Okay. So it's prepared by an individual and it deals with property upon their demise. Ms. Mbugua, in this country, is there any law? We've been talking about huduma number and getting it mandatorily. Is there a law that requires that you must have a will?
Well, there's no law that demands that you must have a will, but there is a law that prescribes the wills, what they should entail, how they are to be governed after, or rather operationalized after the demise of the testator, and that is the Succession Act.
Okay.
Yes.
And what happens if you pass away without a will?
We say you've died intestate.
Okay.
In that case, the estate is governed by the intestate laws. Someone has to apply for letters of administration in the High Court, or if the assets are not so many, in the Chief Magistrate's Court. The court appoints administrators of your estates, and the court will divide the estate unless the beneficiaries agree on a division.
Okay. Cynthia, we were talking about wills, and Mrs. Mbugua has pointed about provisions in the Law of Succession Act, but maybe just letting us know what should go into a will or what ordinarily one should expect in a will would be helpful.
Okay, so what we know about wills is really that someone is trying to make provision for the people that are dependent upon him or her during their lifetime, and they're just trying to safeguard their property so that after their demise, there are no wrangles among the family members. So of course, you're going to identify yourself if you're making a will, and you're going to say that this is the extent of my estate or my property, and you're going to list down the people who you want to benefit from your property. In addition to this, you can also make a provision of how you would want your body to be treated after your demise. That is something that some people like to include in their wills.
Okay, so it has talking about properties, but goes also slightly can deal with a few more things beyond property. Yeah. Now, one of the questions that arises in our cultural context is: are daughters, wives, mothers, are they entitled to inherit? Are ladies entitled to inherit?
Well, that's a very interesting question, mostly because of where we have come from. So traditionally, of course, there were some cultures that did not allow girls to inherit to the same extent that boys are, especially if the girl was married, because the assumption was she would be provided for in the family in which she is joining. But currently, the position is that both female and male children are entitled to benefit from the estate of their parents, regardless of whether they are married or not.
Okay, so a child is a child, or a beneficiary is a beneficiary, whether male or female.
Exactly.
All right, Mrs. Mbugua, what about the position of adopted children? I've gone through the adoption process, and now this person is my adopted child. Are they entitled to inherit?
Yeah, good question. We go to the effect of adoption. Adoption is I'm assuming we are talking about adoption through the judicial process. What it does is to extinguish the rights and obligations of the birth parent or biological parent and confer parental responsibility on the adopting parent. They become like their own children. So when it comes to succession, If you disinherit an adopted child, it's like you've disinherited your own biological child. So the answer is they are entitled. They could actually challenge a will if they are left out. There's another form of adoption in most of our countries where we, especially in the past, where there was no formal adoption taking place, where you bring in a child into your home, but you don't go through the judicial process. That again is captured, but there is no particular law that pronounces so. But from our judicial pronouncements and the history of succession, you'll find those children, we treat them, or they are called children brought in by the deceased, and they are catered for. They are taken as beneficiaries of the deceased.
Okay.
Yeah, and those children can be taken in through marriage. Let's say you marry someone who already has a child. And very common to us is a second scenario where you take your sibling's child or a relative and you bring them up, you educate them. They call your place home.
Yeah.
Yes.
And so what you're saying is that there is the formal adoption process which constitutes you as a child, but the law of succession recognizes even others who may not be either biologically or by law children, but who have a certain right in terms of the inheritance.
Correct.
Now, we've talked about wills and the possibility of not having a will. Would you encourage somebody to write a will, or would you say that they live lightly and not spend time thinking about things that will happen after they pass away?
I would seriously encourage the writing of wills. One, to manage expectation. Because as children, I've realized children watch their parents as they age, and they start targeting that one and targeting that one.
By that one you mean property?
Yes, that one means property. Succession is all about property. And so if you die intestate, the person goes for what they've been targeting. That's why we always have these problems. One, it affects the operations, especially if you are dealing with companies or going concerns, because now I go there and I declare I'm in charge, and so the businesses start struggling. So you need to do a will so that you manage expectations, and secondly, so that your estate can be managed as soon as you die. There is someone managing, because in doing a will, you appoint an executor who moves in soon after death to protect your assets. I think people should also do a will as an act of peace building in their families. You know very well, and some of us know, we are in families where wrangles are most likely to arise. Either going by the size of the assets or the number of beneficiaries, children born outside wedlock, people who are in scenarios where it's not clear whether there's marriage or no marriage. I think the owner of this asset need to do a will so that they peacemake by declaring. Because in many cases, people respect what the deceased said. And so you don't leave your family going for each other's neck. At least we will be knowing what Mzee said before he died. Now, the other reason people need to do their will is to reduce estate costs. If you do not do a will, we said you'll be treated under the intestate laws. The process is longer, and many fights could start at the level of who is to take letters of administration. When you leave a will, you have to appoint an executor. So we jump button number one. We know who is to take probate. And yes. So costs are a big issue in the succession court. So if you did a will, you manage, at least you could safeguard. That doesn't mean someone will not contest a will, but at least there will be something to contest. It is better than where there is nothing. Yeah.